Hi, in this immigration update video, I want to look at a really interesting new case on Article 8 in entry clearance cases, and more particularly in visit visa appeals where there is no right of appeal under the rules. The case is called Mostafa, brackets Article 8 in entry clearance cases, 2015 UKUT 112, and it's a decision of Mr. Justice McCluskey and Upper Tribunal Judge Perkins, who actually wrote the judgment. The case concerns an application by a husband to visit his British citizen wife in the United Kingdom. He had no right of appeal under the immigration rules, but strangely the first-tier tribunal judge allowed the case under the immigration rules and didn't consider Article 8. Now, in the judgment, the tribunal note there is no power for the parties to agree a right of appeal where none exists in law, and they quote the Court of Appeal case from 2013, Verk and others. So there was no power to consider the case under the immigration rules. They also note that there was no power to allow the appeal on a not in accordance with the law basis. Have a look at paragraph 9 in that respect. But interestingly, they say the ability of somebody to satisfy the rules is relevant to proportionality under Article 8. Let me read you the end of paragraph 9. It says, "This is because, as explained below, the ability to satisfy the immigration rules illuminates the proportionality of the decision to refuse him entry clearance." Which is interesting because a number of us thought that in looking at Article 8 in visit visa appeals, the case may stop at the not in accordance with the law question of Rasgar if somebody met the rules. But they go on to consider it under the ultimate question of proportionality, and they apply the Rasgar steps. At paragraph 16, they refer to a 2002 case, which has perhaps fallen out of fashion a bit recently, the case of Shamin Box. That's reported on Bailey as SB Dakar, and the citation is 2002 UKIAT 02212. And in Shamin Box, Dr. Story looks at Article 8 in entry clearance cases, and he reminds us that there's an obligation imposed by Article 8 to promote the family life of those affected by the decision. So it's not just about status quo, it's about promoting family life. Now they say, even though the paradigm case would be somebody to come to settle with his wife, even in this case, a visit application, it did satisfy questions 1 and 2 of Rasgar and wasn't just a technical or inconsequential breach of Article 8, and they quote at paragraph 16 VW Uganda. So the tribunal go on to allow the case under Article 8 and say, look, the rules are met, the rules would have been met, we can't allow it under the immigration rules, but we find the decision not to allow the claimant to visit his wife disproportionate. Let me read you paragraph 21 because I think it's helpful. It says, in these circumstances, the entry clearance officer must justify the interference and satisfy us that the interference is proportionate, subject to 2 sets of considerations. Now, I'm not going to read you the rest of it, but let me give you the 2 considerations. The first consideration is about honesty and refusals under the general grounds. If somebody's been dishonest and has lacked candour in an application, that may lead to a dismissed appeal under Article 8. The second thing is case-specific considerations as to how the relationship was affected. In this case, they look at the particular relationship. But in some cases, the relationship won't be affected that much by the lack of ability to visit, so you won't succeed. So don't think this is carte blanche, that if you meet the immigration rules, your case should be allowed under Article 8 on a visit visa appeal. But you need to address the case sort of specific application to the relationship in question. And remember, in this case, it was a first-degree relationship. It was a husband wanting to visit a wife. In wider relationships, it might be more difficult. But I think this is really helpful guidance in visit visa appeals under Article 8, and also perhaps to be used for the wider application of Article 8 in entry clearance cases, because often judges are not really engaging with Article 8 in entry clearance cases. But it might be interesting to apply to Appendix FM cases where EX1 only applies in-country and doesn't apply out of the country. But have a look at Mostafa, some really helpful stuff in terms of Article 8, visit visa appeals and entry clearance.